We're going to go ahead and go forward, and I'm going to introduce yourself, please.
My name is Elizabeth Harris, and I've been Connie's client for about 7 years now. My child got involved with the court system, juvenile court system, and we had a lot of problems, and so we ended up filing a suit, and qualified immunity was a big factor at play, and so Connie is going to talk to us and explain that.
Yeah, and a really good thing about having Elizabeth here with me is, since she's not a lawyer, when I start kind of explaining something, I've said, she can kind of help ask the questions from the layman's point of view and talk about what we did and why we did it. So before we start on qualified immunity, I'm going to give you a couple quick updates. This is September the 13th, middle of September already. This year is just flying by in spite of all the tragedies and epidemics and all the crazy things going on in our world. I can't believe we are into third quarter. So it is a couple of really great things happened this week in the world of child welfare reform, which I work all the time. One of them is I had a great meeting with a person out of Nashville who's a great community leader involved with sort of community. I'm not going to give away too much right now as far as his identity, but we had about a 2-hour meeting where I explained to him kind of the overview of Title IV-E and the new Families First Act, and he totally gets it. He understands evidence-based and best practices and stuff that we need to start putting together. So he and I are going to get together again on the 21st. I also had on Friday night, I got to go to the Williamson County Republican Party Reagan Day dinner, and Devin Nunes was there. And if you watch politics at all, you know who Devin Nunes is. He is a very vocal conservative, and he had somebody from his staff there that actually deals with the family issues and child welfare issues. So I spoke to him about it. I got that contact information. I also spoke to my state senator, Jack Johnson, and told him I needed to come in and have a meeting with him related to the change that had happened on the federal level and what I felt the status of DCS was in the state of Tennessee now with the commissioner that they have on board, and he welcomed me to do that. So that's just kind of personally, I'm getting sweaty, the things that I've been doing. And so now the big thing, though, was this. So I'm going to put this up here so you can see it. As you can see there at the top, it says, and it may be backwards for you because I know that's kind of the way it does, but it says in the Supreme Court of the United States. In the Supreme Court of the United States. And the case is J.H. v. Williamson County. So this is a case that I have worked with Elizabeth on since 2014. And since we're here, I told her we were only going to try to do this in 20 minutes, and that goes pretty fast. But I think it's important to talk a little bit about how we got here and kind of what happened when I first got involved with this case. Now, as often happens in my life, people come to me when they already have all these bizarre things have happened in their cases, and they come in and they try to tell me what's happened or what's not happened. And I mean, for a long time, I'm like, no, that couldn't happen. No, that couldn't happen. No, that didn't happen. And I mean, Elizabeth's case is one of those. And she came and first met me in about February of 2014. And it was a case where her son had and I'm going to let her tell you what it is, because she's so much better, but he suffered from pandas. It caused a lot of psychic disturbances. He ended up in juvenile detention, not convicted of anything. He was never convicted. He was what is called a pretrial detainee. Now, under the Constitution of the United States, a pretrial detainee is not to be punished while incarcerated. So she first came to me, though, and we had some real concerns about the way he had been treated while he was incarcerated, and then just the ongoing issues of not being able to get out of that system. So tell them a little bit about that.
Well, we first got involved with the juvenile courts in May of 2013. My son had pediatric autoimmune neuropsychiatric syndrome associated with strep, and that just basically means that when he would get strep throat, it would go to his brain, and he would have behavioral issues that were really basically unexplainable and very difficult to deal with. And we had gone down the road of trying to get medical treatment, and that was not working out. So we were hopeful that the courts could help us find resources that would be able to help us. Unfortunately, that's not how it worked out. And they ended up, as we know they do now, that's the protocol, is insisting on adding a lot more things for you to do as the parent and checklists that as if you didn't have enough to already do. And then your life becomes 10 times as stressful as it was before you got involved. And not only that, there was just, the way the whole court system runs over there is just completely not efficient. And so there's 10 people trying to do the job.
And while they're continuing to do more harm to your child, by the way. I mean, and not only are they, and you all know this who have been involved in child welfare, it's like parent goes for help and resources, they make the parent's life miserable, and then they're continuing to harm their child.
Well, because then your focus completely has to become on unwinding the situation in the courts and who all's involved and trying to go through papers and understand what these petitions mean against you, against your child, what's going to happen next. And everybody seems to be afraid to get involved. And so we did have an attorney at the time. Things progressed from bad to worse. DCS got involved. Then we were finally able to get him some medical treatment, but it was $20,000 out of pocket. We had to drive really far. It took 6 weeks for it to kick in, and so he had it exactly. And so he had an issue before he could get completely resolved with the treatment that we got him, and he crashed a car. So they picked him up again, and by this time they've decided he's a delinquent. I'm a bad mom because I can't get him what he needs, and even though this is a very rare syndrome to deal with. So I got
a syndrome that they didn't even believe existed, by the way, right? I mean, they're like, no, I don't want to hear. And that was part of the problem. I mean, the court itself was rude, extremely rude, and even at one point said, I don't want to hear any more about that as far as having a physical disorder.
Which is similar to, I don't want to hear any more about your cancer, is exactly what that's like.
Exactly.
So, you know what, that just really struck a nerve with me. And so from that point on, I thought, this is not only for my child, but this is a protocol in place, and it happens with every child that I saw walk through there, and it just hurt my heart to see these parents and these children not having a clue what was coming down around them. And so I kind of, got a bee in my bonnet at the time that I just wasn't going to let it go, because it's not, most people don't have the resources, or they don't have a Connie, so it's kind of, we've picked up the, torch for, hopefully maybe we can make some changes here, because it is just all consuming. It takes years to get through, and very, 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 very sad. But ultimately the judge took, I think she just really kind of got a vendetta against me because I wasn't going to.
Yeah, like having you arrested for trying to get your son medication. Yeah, I would say that's a vendetta.
I mean, all of the illegal things that she did and said, and the things that were going on in the back, the cahoot, because I wouldn't agree to do this or that or sign their petitions. I'm in business. I'm not going to sign anything that I don't completely understand. And I'm certainly not going to sign anything with someone standing there trying to pressure me to sign it. So ultimately, and I don't know if she, for what reason she really did this, but there was some sort of an altercation, I guess, at the detention center with words only. They pulled my child out and put him in solitary confinement.
Just barely turned 14 years old, but a 14-year-old disabled child, put him in solitary confinement. Basically 23 hours a day.
23 hours a day, who had just had this exorbitantly expensive medical treatment, and just put him back in that dirty jail cell and just left him there, locked the key and left him there. And the more I said and the more disturbance I made, the worse things got to.
And then cut you off from
eventually the point where they just cut him off from speaking to either of us. I mean, he wasn't, and basically they literally drove him crazy in that cell. Looking at the reports afterwards, it's really hard to think about.
Well, and also this went through Thanksgiving. Was the very first time this child, not only was he just locked up, which is, that's very devastating for a child. He knew a holiday, it was Thanksgiving, and he had no contact with any of his family at all through that holiday. And and we can't get into all the details, but basically ever since, that holiday's been a trigger, wouldn't you say?
Holiday's been a big trigger. And then when they finally released him, that it was with stipulation that he was not to discuss anything negative that happened while he was there. Even to the point of not being able to.
And you weren't either.
And I wasn't either. And it was just like I never in a million years would have believed that this stuff went on unless I had walked it. Mm-hmm. And my eyes were opened, and now I've woke up, and once you see that, you really can't live the rest of your life not doing something about it. So
Yeah.
fortunately, Connie took the case, and basically then after I had disagreed with not signing whatever, they wanted to get him into a place or facility and get custody away from me because they knew that I was not going to let it go. And so, but if they could get custody, then they could, it wouldn't be a problem. So I brought Connie in to help me retain custody of my child. And so that's where the story went. So when I flew in to tell her the whole thing, she was like, what?
What? And it was right after. Okay, so they finally let her child out of the detention center. Still put all these kind of crazy restrictions that, you know, he couldn't live with mom and they couldn't talk about anything. And, you know, she was limited. They were going to try to place him. We didn't even get into that. But they were going to try to force place him into a facility that was totally inappropriate. We knew, and she knew it was. She still hadn't met me yet. And then because Elizabeth kept putting her foot down and saying no, then the judge orders her to do a psych eval and a lot of these people out here are facing that, and tell them what she told you about the psych eval.
Well, it was just like, you know, I had my checklist, I'll do this, and every time that her plan didn't work out, she would come up with something more. It was like she would raise the bar for the next thing that I had to do. I mean, she was going to win. This was not just an issue of what was best for my child. This was an issue of who was in control and what was going to happen next, and she had the final say. And, you know, I just wasn't going to go with it. But I will say that one big thing they did was they took my medical decision right away. And so, therefore, I couldn't even take my child back to the doctor to get the follow-up appointment for the big medical treatment he had. So I'm in the midst of all that. And then finally what I ended up doing was I answered her petition, but I really had a second lawyer who was answering it, but I had the other one on file because anyway, that really made her mad. So she said that day, Ms. Harris, if you can afford to have two lawyers, I was like, I can't afford it. This is necessary. Then you can afford to have a forensic psychiatric evaluation with collateral corroboration by 8 physicians overseen by Dr. Montgomery at Vandy Psych. And I was like, oh, I'll never be doing that. Nothing. I don't even think that's a real thing. So anyway, I mean, it is scary because I'm like, I'm not going to that. And so it's like, what do you do? And so the story is unbelievable, but sometimes the truth is stranger than fiction. And I mean, I think it was a total God thing. I mean, because like I got her name in this other situation I was trying to get out of to get to the next step, and I was like, and somebody just said, here's who you need to go talk to, and I just basically drove straight to her office, and by the time I got there I was just a disaster, and I was like, I'm out of cards to play. I played my last ace.
So I want to take you to that spot because I mean, literally, she was pretty much a mess when she finally got to my office, and she said, I already have a psychiatrist. I already have somebody our family has worked with for, 4 or 5 years, and she gave me her name, and it happened to be a psychiatrist who I had known, I had worked with before, so I knew she was, legit. And so I said, well, you need to get her testimony in the court. And Elizabeth was like, well, I've already taken her to court, and the judge wouldn't let her testify. And I said, okay, well, we can fix that. All you have to do is put them on notice that you're going to do an evidentiary deposition, give them a date, call the doctor, tell her you're going to do an evidentiary deposition, hire a court reporter, and go in, and when you get it typed up, you're going to file it with the court, right? And so she's like, oh, and she had no money. And so I'm like, okay, here's how you write it up. And so I handed it to her. Because she's like, she's going to do it. She's a wolf, right? She's going to do it. So she's wolf mama now. And so she goes down and she files it with the court, gives it to the guardian ad litem, gets it set up. We get the court reporter scheduled. And like that morning, because it was at 1 o'clock. And so at that morning, I knew something was going to happen. So she calls me up. She's like, can you do the deposition for me?
I stayed up all night. Listen, I stayed up. I was like, so this is not how court should be working for the last 4 months. So I'd been watching, I pulled out all the juvenile court rules, read them. I was like, they're not doing that. They're not doing that. So I didn't know, but I tried to write the questions out. I mean, and I practiced. I stayed up all night practicing them, and I was like, I don't know if I can do this.
And so she calls me up, and I happened to not have anything hard set that afternoon. I'm like, sure, I'll go do it. So I said, we'll just work out something. You just pay me for the deposition. And then we get there, and like I said, I know this doctor. I've seen her do depositions before. We go in, and I go, you probably don't even remember this. And so I said, I'm just going to use Dr. Brown because I don't know if she'd want us talking about her right now, but I'm just like, so Dr. Brown, are you familiar with Miss Harris and her son? And she says, yes, I am. And I'm like, how long have you been involved with them? And she gave whatever year. And I said, so could you just explain to us on the record a little bit about what you know? And she just like took off. I like didn't have to say anything else. I like... and Elizabeth's sitting there like, that's all there was to it?
It's all like, what is your middle name?
I can't do this. And so I'm like, okay, we're going to get through this. I mean, you're so nervous you couldn't have done it. You would have like been cutting her off. Like, you would have been like, okay, but that's not the question I asked you.
Exactly.
So anyway, so we did this deposition, and I mean and then the guardian ad litem there. Well, she asked her like some stupid question.
She always asks stupid questions.
The guardian ad litem like so clueless, and so we get this transcript. We get the transcript ready to go, and you file it with the court, and they like dismiss it before you get to court.
But that's not the only thing you helped me do.
What?
Because I had been pouring through papers. I had made these boards all over my walls, stuck every document up there, hundreds of court documents. Who can keep up with that? Posting them everywhere and just trying to figure it out. And in the meantime, I learned how to write a subpoena. And so I started sending out all these subpoenas, but I mean, I didn't really know how to do it, but I typed up like 10-page subpoenas. I need this from 1946. I need this from, I need all the communications between your CEOs. I don't know.
Right.
So Connie thankfully let me like put care of or something to where like when they all got where they were supposed to go, people like actually thought they were
prepared with assistance and counsel. Then they get them, they're like, oh, and then what happened? Oh, because you
said a bomb must have blown up because you started getting all these phone calls.
Oh, yeah.
Then they hauled me into court to quash them. I mean,
yeah, but wasn't it the day they hauled you into court to quash them that they dismissed everything?
It was around that time, but
it was exactly because they didn't want to have to comply with those subpoenas, and so you get to court and they're like going to quash him. Plus, you've got the deposition of the mental health person, and the court's like, I think it was the guardian ad litem's petition, wasn't it? And the guardian ad litem is like, oh, I'm dismissing that petition.
Okay, so all of a sudden, within 30 seconds, because we did his deposition and some subpoenas, it all went away. I never did anything wrong. I'm not a bad mom.
Right.
I get to take him home today. That is so wrong.
Yeah, totally dismissed.
So
Same
wrong.
thing happened to Wendy. I don't know if Wendy's on here yet, but we went through the whole juvenile court proceeding. They hammered us. They withheld documents. They withheld discovery. They impugned us. They got judges to sign secret orders. We go through the juvenile thing. They have this big hearing. They're like, oh, she's a terrible mom. I'm like, okay, I'm appealing that to another court. We appeal it to circuit court, and we're a week into filing the appeal, and they like call us up and they're like, we're going to dismiss the petition, and the kids are coming home Friday. Yeah. So all that.
And we don't even owe you so much as an apology for everything we put you through. I mean,
exactly.
Or your kids.
So now we're going to fast forward a little bit because a whole lot happened after that over the next 3 years because her son was so psychologically damaged from the things that had occurred that we went through a lot over the next 24 months, probably still having to help him with some things, but able to get him, some help, some therapy, going back to court a couple times. But anyway, ultimately, I filed a federal civil rights action against them in his behalf for the improper medical treatment and the solitary confinement. So we sued the Williamson County, and we sued primarily two people who were in a supervisory position at the detention center, which is Steve McMahon and Betsy Adjent. And they were the ones who were responsible for the day-to-day care. And we found out so much when we got those records because, I mean, they should be giving these records to parents, but all the detention records that really showed that for those first 3 weeks that if they had him in solitary confinement, that they did not document anything. And yet when we started deposing them, I mean, they started disclosing about all of the things that they were dealing with him. None of it was reported to the parents. I mean, you know, him having nightmares and waking up and screaming and none of that. I mean, if that happened in a parent's home, DCS would be called and getting involved all the way, but they can throw your child in jail for a medical condition and then allow him to suffer like that. So we filed the civil rights action in 2014, okay? So we allege that the solitary confinement and the lack of medical care, mental health care while he was there was basically a 14th Amendment a violation. So under the 14th Amendment, now we're going to get into the legal stuff. So and Elizabeth has like really read almost everything we've ever done and has really kind of tried to follow and as a layperson kind of learn how all that fits together. But under the 14th Amendment, there is a procedural and there is a substantive due process right. And the procedural is notice and opportunity to be heard before any of your rights are deprived. And then the substantive is the actual liberty interest violation, okay? Real important. I know lots of parents, lots of families out there want to know if they can sue the state. Well, you can't sue the state. You have to sue the workers. You have to sue the actual people who are doing the things to you. But there are, when they are intruding on family rights or there's, denying you access to the courts, they're primarily under the 14th Amendment. A few of them are First Amendment issues. So in this case, we allege 14th Amendment violations of toxic conditions of confinement for a pretrial detainee. So we go through depositions after depositions after depositions, and we were just talking. We're at the cabin, by the way, if you haven't guessed from the background, but we were talking last night about because we videotape like every deposition, so we now need to go like pull some of the excerpts from the videos and show you the absolute, not 3 weeks, he was 21 days in solitary. 5 weeks. 5 weeks in solitary. There was a 21-day stint, and then they kind of looked at it in two different ways. So when you are thinking about whether or not you can sue, you have to sue the individual for their individual violations of your rights. So in this case, we did all these depositions. Oh my gosh, the craziness we had to deal with in depositions. And it had to do, part of it was the fact that they would not accept the diagnosis of the child. We had to go to Florida. We had to go to Virginia. We had to go to Kentucky to do deposition. Utah to do depositions. And we were Washington. We were going all over the place. And so let's just tell them, before we get into qualified immunity, we have to tell them a couple of our experiences because, it would be so bizarre. As horrible as everything is, I see comedy and just so many bizarre things. When they happen, you just have to laugh about it. You just have to go, oh my gosh, I cannot believe that. So, and there's key things. Like, for instance, we had to go all the way to Florida to do a deposition with a Dr. Schulman. Dr. Schulman out of Chicago. And this guy was a neurologist. And, I'm
chief pediatric neurologist
at
Lourdes Hospital.
Yeah.
So he's like this,
he's like the top of the top of
research.
The top. Yeah. He's like the top of the top. So this was Williamson County's expert witness to dispute the fact that this child had a medical condition that caused a neuropsychiatric symptoms, right? This was their chief witness. And so I Googled him, of course, before I go. And one of the things is I Googled him and the disease pandas, and there was a 2012 article or something. So I printed that up and I brought it along. And what we found through this, which is a whole nother video we probably need to do sometimes, but there was a real divergence in the medical community about whether or not these neuropsychiatric symptoms had a medical had something medical that was happening in their system or whether they were crazy, right? So the neurology people and psychiatrists just want the kids to be crazy so they can just medicate them. But so we get down there and I have this 2012 article where they hand us a resume. Oh, plus he was charging us like, what was it, $600 an hour, right? We had to pay him like $600 an hour to do his deposition. And so I'm like, and it was a 2-hour minimum. And we were like studying the night before. Again, she has a list of like 1,800 questions. And I'm like, I am not going over 2 hours with this dude. I don't know what it's going to take. I'm going to chop him off at the knees within 2 hours. And so we get in there and I'm like, oh, is this your resume? And you got all your publications in here. And, I only see like 2 publications ever about pandas. And one was like 1992 or something, right? And then there was something like 2008 or something. And I'm like, well, you've got one here from like 2012 and it's not on your list. He's like, going through his list. He's like, I'm like, and he goes, well, it'd take me a while to find it. And I'm like, well, you have them in chronological order. So all you have to do is go to 2012 and see if it's on the list. And he's like, oh, I'm just going to have to get off from my staff about that. And I'm like, okay. And so then he was saying that the child, wait a minute, that
didn't have it.
He said that it was his expert opinion that this child did not have pandas. And obvious from his, 3 articles that he had ever written on it, which were not research articles, they were opinion articles. But on his 3 opinion articles that he had written, he didn't believe it existed. He thought it was false. And so I said to him, I'm like, so if you don't believe it exists, how can you say he doesn't have it? And he was like, blah, 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 blah. And I'm like, we're done. We're out of here, right?
You won.
I'm like, here's your $1,200. We're going to take a walk on the beach because we got a plane to catch.
And we found a sponge.
And we found a sponge on the beach. So, that's just kind of the crazy stuff. Their other expert was a psychiatrist in Chattanooga named Dr. Holmes, who now works for the, I don't know what it is, you folks in Chattanooga know, but the state mental facility down in Chattanooga. And he was basically saying that he didn't believe it either. And he was, what was it he said? What was the thing about Wikipedia?
Well, he was kind of trying to explain it, but the wording was very eerily similar to the description in Wikipedia. And I was like, honey, hold up. So we're always like secretly talking under the table.
Yeah. With phones. And she's always like looking things up on Google.
And she's like, did you get that definition? Did you just actually get that definition from Wikipedia? Or she said, how did you get to that article you're reading? And ultimately it was Wikipedia.
Yeah, well, I think you first tried to say Google Scholar. And I said, it's funny because if I go to Google Scholar and I type in pandas, I get 100 research articles on bears procreating.
That's what happened. Yeah. Okay, then he admitted it's Wikipedia.
Then he admitted it was Wikipedia. So I'm like, good Lord, these people are crazy. So we've worked and we worked. Anyway, let's get back to our lawsuit and our Supreme Court thing, because that's one thing I really wanted you to understand today. So when you are in federal court, you're in district court first, which means you're in the state. So in Tennessee, we're in the Middle District Court of Tennessee. When you get dismissed, and I'll talk about that in a second. When you get dismissed in the Middle District, you go to Sixth Circuit. Sixth Circuit Court is in Cincinnati, Ohio, and our Sixth Circuit Court includes Michigan, Kentucky, Ohio, and Tennessee. All right, those are the 4 states in our district. So we have to appeal to Sixth Circuit, and we have the 3-panel judge there. You don't put on new evidence. It's basically on the record, and it's a lot of legal arguments. So we went and we did that, and actually I posted part of that, at least part of the audio. We had one judge up there who was very, very compassionate. Judge Stranch was very compassionate about what happened. And then another judge wrote the opinion, and he dismissed the case again and so we had to appeal. So let's talk a little bit about the dismissal. So in the district court, the 2 main issues there was the solitary confinement and the lack of medical care. So In the district court, you have to prove two things in a civil rights case. Number one, you have to prove there was a constitutional violation, a violation of a liberty interest. And number two, you have to prove that it was clearly established when the events occurred. Now, you've heard a whole lot about qualified immunity lately in a variety of things, primarily in police cases, but this is this is not a police case, so it's a little bit different, but you have to meet both of those criteria. So the civil rights cases really started being filed, and I mean, it goes back to, I think there was a case from 1950 I was reading about a naval officer, but primarily you're talking about the 60s and 70s. A lot of issues came up with voting rights, about blocking voting rights of African Americans. Those became civil rights issues. A lot of them morphed into prisoner issues and police issues. So excessive force, unlawful entry, prison disruptions where prisoners would be brutally beat up or mistreated while in prison or put in solitary. I mean, there have been solitary confinement cases. So then there was a case in 2002, and it said that it's called Hope v. Peltzer, and it's a case where they said, well, you don't really have to have a case that is clearly on point. You can look at the facts of the case, and if the facts of the case are so egregious that the state person who did it should have known that they were violating a liberty interest, then you can say it was clearly established because they should have known. The standard is they should have known, they should have known, they should have known. Now, a civil rights case is a tort. It's a tort action. A tort action is just like in civil law, it can be a trespass, a car wreck, slander, defamation. Those are all torts. They are personal injury cases. And when you if there's a lawsuit between me and Elizabeth for libel and slander, and I'm suing her, and part of the thing that I bring up is that she was either negligent or she intentionally violated my rights, just my personal rights. So when you go to under a 42 USC section 1983 case, you are looking at, did that state person, that state actor violate your constitutional rights? And you would think that the standard would be some kind of, it can't be just negligence, it has to be a little bit more than negligence. There has to be some intention or some deliberate action on the person, but it should be a negligence standard. It should be a tort standard, and not a standard that says that unless there's a case that happened before, exactly like your case, and we found it was a constitutional violation, then you have no relief. And just think about ultimately how ridiculous that is. So that's like saying that you sue somebody in a car wreck because you were going 20 miles an hour down the interstate and they were going 70 miles down the interstate. And the court says, well, we've never had a case exactly like that. So therefore, we're going to say it was the wrong thing to do, but you don't get any relief. Okay, so that's really the standard of the law. And over 2,000... Put in there. That was so gross. So over 2014-15, then they started narrowing this and basically saying in excessive force cases that you had to show exactly a case on point. All right, so that's the standard of the law. Now, in the past year, a lot of people are trying to take qualified immunity to the United States Supreme Court. Several people have tried to take it up there, and the Supreme Court has said no. So when I looked at our case with her son and how could we get the Supreme Court to look at this issue, I said we have to narrow it down. So if you want the Supreme Court to look at an issue, you've got to narrow that issue as tight as you can, and then say, here's the reasons why that issue has to be brought before a court to be decided. And so in this particular case, for children, there was plenty of authority out there that said you do not put children in solitary confinement. And I'm going to let you, actually, I want them to know what it is. I'm going to let you read some of that to them while I go get a tissue. All right, so this is I haven't uploaded the entire brief at this point. I probably will do it at some point, but I want to try to share this with perhaps some media outlets or some people who really follow civil rights cases and have them talk about it. So, and you don't have to read them word for word, but I just want them to know how much was out there for making this determination. Good Lord, look at that. All right, so we're going to start with in 1990. So kind of go through these with them. And again, you don't have to read them all word for word, but you can kind of look at it and you can kind of tell them. And here's the point. Here's all the things that were available to the people who worked in the detention center as professionals who deal with and take care of incarcerated children that they should have known about as professionals. And I'll be right back.
She'll be right back. Okay, so in 1990, the United Nations rules for the protection of juveniles deprived of their liberty and prohibits the use of solitary confinement. This resolution was supported by the United States. In 2003, Congress enacted the Prison Rape Elimination Act, denouncing solitary confinement except under extremely rare circumstances. Tennessee agreed to be bound by its terms. In December 2010, the Tennessee Department of Children's Services adopted and recognized the standards set forth in PREA in Administrative Policies and Procedures 18.8. And that was the question that I had, was that clearly if someone locked their own child in a cage and left them there for 5 weeks, this situation would not be in question. That parent would be arrested and probably jailed, and their children would be removed from them. And even DCS's own policies state that they don't use isolation for punishment of any type, and I think it's not over 24 hours. So to leave a child in there for 5 weeks is just it's just unbelievable to me. I can't even fathom it. And the Juvenile Detention Center operates under the oversight of DCS. In 2013, PREA prohibited isolation except as a last resort when less restrictive measures are inadequate to keep them and other residents safe. So this is like a disciplinary separation. However, my child had not really done anything, and the thing that they did accuse him of, they did not give him a hearing on. So Connie is back and she will answer your questions. I just told him about how
U.S. is not a signatory to now. So the 1991, I'm not sure about, James, but there is a second UN resolution. I think on here it's 2012. Hold on here.
over that one too.
Okay, hang on. Let me flip over here real quick. Yeah, 2012. Yeah, I'll come to that in just a second. All right, how far did you get?
I was explaining that one. DCS's
Okay.
own policy.
All right, so she's gone through some of them. There was also in 2004 was this DCS policy that said that they could not use seclusion as punishment. In 2006, the Washington University Journal of Law published an article, a very extensive article, on the damage of solitary confinement. And here's how they used that against us. They said, well, that was about grown-ups. That was not about children.
It's like they can weed. I've never seen anything like it.
Yeah.
They spin words. I mean, and they can get out of basically anything.
Right. And then in 2010, the Journal of American Academy of Psychiatry and Law published an article on solitary confinement and mental illness in U.S. prisons, and describing the psychological stressors of solitary as clinically distressing and as physical torture. In 2012, the American Civil Liberties Union, the ACLU, published Growing Up Locked Down, stating that prolonged physical and social isolation in young people raises serious human rights concerns. And then they cited cases from all over the country, as well as a case called Roper v. Simmons by the United States Supreme Court in 2005, in which the Supreme Court stated the punishment of children must consider their age and special development needs. So in 2012, The American Academy of Child and Adolescent Psychology, which is known as the AACAP, published a policy statement defining solitary confinement as placement of an incarcerated individual in a locked cell with minimum or no contact with people other than staff and as a form of discipline or punishment. And they said that the psychiatric effects of prolonged solitary included depression, anxiety, psychosis, and it was specifically prohibited as discipline, coercion, convenience, or staff retaliation. And then in 2017, it was after this had happened and we had filed her case, but there was an injunction issued by the Middle District of Tennessee against having solitary confinement for juveniles, and they used the very same laws to base that on. The TCI, Tennessee Corrections, minimum standards for juveniles was the controlling authority in 2013, and those rules directed the facility to hold disciplinary hearings within 72 hours, which they did not do. There was an abundance of authority of fundamentally similar issues of which they should have known. And then also when we had filed our Sixth Circuit, we were very lucky to have gotten an amicus brief filed by it was filed in behalf of professors and practitioners of psychiatry and psychology, and they cited numerous articles as early as 1989 on the dilatory effects of solitary confinement, which included Insights on the Adolescent Brain, 2008, a position statement on segregating inmates with mental illness, 2012, Human Rights in Solitary Confinement, 2012, The Effects of Solitary Confinement on Juveniles, 2012, Acute Psychosocial Stresses on the Brain, 2012, the United Nations Report on Torture, including the use of solitary confinement, 2011. That's the other one I was talking about, James. And yes, actually the U.S. is a signatory on those. There's another separate one that they're not a signatory on that has to do with children. Prison Offenders with Mental Illness, 2003, Psychiatric and Pathological Effects of Solitary Confinement, 2006, and repeated references were made to the 2006 study that I've already talked about that was in the Washington Journal. So this 2006 published identified the common psychological injuries resulting from solitary confinement, including depression, hallucination, cognitive dysfunction, memory loss, anxiety, paranoia, insomnia, withdrawal, lethargy, stimuli, hypersensitivity, and panic. They recognized that life-threatening behaviors such as self-mutilation and suicidal ideation were common among prisoners that had been placed in solitary, and that in 1998, professionals opined that physiological injuries of solitary confinement included hypertension, heart palpitations, a decline in neural activity, gastrointestinal disorders, severe insomnia, and weight loss. The brain research as early as 2013 articulated the physical injury at a subclinical level, including adverse effects on neural pathways and neurochemistry in the brain. The United Nations Report on Torture, published in 2012, declared that solitary confinement should never be used on juveniles or people with mental illness. So our point was that there was ample authority out there for these people who are professionals in the industry of child welfare. Should be they should have known what they were doing. And the other thing I bring up in this brief, as I mentioned earlier, a lot of the cases that are keep narrowing the scope of qualified immunity, basically saying you have to find a case on point. Most of those are excessive force cases. So those are cases that have to do with either a high-speed chase, the arrest where they're trying to arrest somebody, and there are signs and indications that the defendant is going to be violent. And so they're substantially different, because when you think about it, people in those situations have to make split-second decisions that are life-threatening, and they and it's always changing, right? Like a high-speed chase, they change. They're all constantly evolving. But in a case like this, where you have a child who's put in solitary confinement for 5 weeks, there is plenty of time for the state actors and the staff to consider the consequences of what they're doing. And that's a huge, huge difference. So I talk about in here that where the actions of the state actor are deliberate and enduring, and they have time to contemplate what the results of their actions, then the standard for qualified immunity should be different. And that's where now I'm going to circle back around to parents, because right now a lot of people are coming to me about ex parte orders to remove your children. And if your child is not in immediate threat of harm, and I mean immediate threat of harm, that is harm, just a crack house, a meth lab in the basement, obvious injuries to the child, or real credible evidence of sexual assault, because I take that very seriously, that the parents should be entitled to representation and a hearing. And I'm getting, I know I deal primarily with Tennessee just because that's where I can effectively give some type of insight or legal background. People have contacted me from other states. I'm going to tell you about a couple that have come across my plate recently. One of them is in Hickman County, where the judge apparently delegated a clerk to sign her name, that's the judge's name, to ex parte orders without the judge even ever seeing it. And so that, I think, is very much a due process violation, a substantive and procedural due process violation. In another place in East Tennessee, the social worker obviously had an axe to grind and caused the cops to come out and meet her to take a mom's children away from her, tells the mom there's a court order to remove her children from her home when she did not have a court order. And when they were able to get some records on that particular DCS worker, they found that she had been severely sanctioned for not following policies in the past, and yet DCS continued to let her get out here and do that kind of work. So that is, this has been a little longer than what I wanted to do, because I like to keep them 25 minutes. I didn't do that. But anyway, thank you all.
You should say it did end up giving him PTSD.
Yes.
So all the literature is true, and then we had to sort out the pandas and the PTSD. So,
and I mentioned earlier about the records. Finally, they started documenting in the records what they were observing on a day-to-day basis, and when they and it still was not complete, I'm sure, but when they finally started documenting it in the records, they had evidence on their own that he was having a psych breakdown, and they did nothing about it. They never got him mental health. And I could go, it's a whole nother discussion about going into why they denied him relief, civil rights relief under the mental health. But, I think they were wrong in dismissing that as well. But that is a little bit blurrier battle, because it is facts. And unfortunately, as all of you know, the facts often become whatever the judge says the facts are. And unfortunately, that's what happened to us. So the facts, if they are not real crystal clear, you have the challenge of making sure that those facts come out adjudicated the way they're supposed to come out, as opposed to the judges and the courts twisting them all around. And like in that case, basically they said they had relied on other medical providers, but the truth is they didn't tell the medical providers what was going on in the facility. So, so this is a mom who's worked super, super hard. I also wanted her here with me today because I know how horrible and how hard this is for so many of you. And every week it seems like I get a message from somebody, they're giving up, or they're hiding, or they're about to shoot somebody, or, and I understand that, and it's, and I can't promise good results at the end of the day, but, you have to take this on as a mission. So this is not something she wanted to do with her life. No.
No. So, absolutely. Just hang in there and don't lose hope. It'll feel like, there's nothing left to do. You're at the bottom, but just don't give up.
Don't give up. Don't give up. That's our last message. All right, y'all. Thank you so much. And we're going to enjoy a little bit more of the countryside. If you're on my personal page, you saw You saw some of the great photos, the great Tennessee photos. We took a nice long walk at Stone State Park this morning. So we're all going to say goodbye. Please pass it around. I'll also put it up. I'll probably put up in a couple segments on YouTube and reshare it so that you can make sure you're sharing it with other people so we continue to educate people on the things